Good morning and good afternoon to everybody out east. Welcome to today's session, and thank you so much for joining us. My name is Salim Vizram. I'm a senior associate here in the employment group in the Vancouver office with Dentons, and I'm going to be the moderator of today's session. I'm thrilled to be joined today by three of my colleagues from across the country. First, we have Colleen Hoey. Colleen is counsel in the employment group in our Ottawa office. Her practice covers management, employment issues, including employment standards, contract risk, and discrimination and harassment claims. Today, Colleen is going to go through two recent decisions from the Ontario Superior Court. The first deals with an allegation of reprisal brought by an employee, and the second addresses an award of punitive damages in a wrongful dismissal action. Next, we have Meredith McCall. Meredith is a partner in the firm's intellectual property and litigation and dispute resolution groups, and she works out of our Toronto office. She works closely with the employment group to advise on ways to protect employers' intellectual property and to prevent former employees from infringing on an employer's IP rights. And so today she's going to provide a crash course in exactly that. And last, but certainly not least, we have Eleni Caceres. Eleni is a partner and the leader of the employment group here in Vancouver. Her practice covers a wide range of industries, and she is widely recognized for her practical, commercially aware approach to complex employment and labor issues. Today, Eleni is going to go through a very interesting decision from the BC Supreme Court, which has to do with providing working notice of termination. And she'll also provide some practical tips for when to consider providing an employee with working notice upon termination.
Good morning to colleagues out east, and hello to everybody else on this snowy day. So today we're going to be talking about two recent cases that serve as cautionary tales. The first is a story about reprisal. It is the first ever case to consider reprisal section of the Ontario Securities Act, and it resulted in a $5 million award against the employer. The second is about what began as a regular wrongful dismissal claim involving a salesperson with 3.7 years of service, but resulted in an order for 12 months of notice and a $57,000 damages award. So how did we get there? How does everyone else avoid a similar fate? So if you're at lunchtime, grab your sandwich. Out east, out west, grab your morning coffee, and we'll begin. First slide, please. So McPherson and Global Growth Assets. The defendant in this case, we can move actually even to the next slide. The defendant sold education savings plans, and due to the nature of its business, it was regulated under the Provincial Securities Commission. Now, this company was indirectly owned by an individual by the name of Sam Bougee. Mr. Bougee and the commission had some history. He had been sanctioned for misconduct on multiple occasions, which led to his permanent suspension for acting as the ultimate designated person. So quick sidebar, under Ontario securities law, registered companies are required to appoint a ultimate designated person, or UDP, and that person is ultimately responsible for promoting regulatory compliance. So the company was ordered to replace its CEO, after which the plaintiff, Mr. McPherson, was hired as CEO and UDP. The other defendant, Ms. Bougee, was the daughter of the former owner, and she was now required to report to Mr. McPherson. She bristled under this, despite the fact that a lot of the departments for which she was responsible had direct impact in areas that were regulated under the Securities Commission. Nevertheless, the board ordered that she would no longer have to report to Mr. McPherson, but rather straight to them. This concerned Mr. McPherson, and he requested an in-camera board meeting to raise concerns over potential oversight issues. Rather than grant the meeting, though, the board terminated his employment after only 6 months of service. In response, Mr. McPherson brought a claim for wrongful dismissal, and he claimed that this termination was in violation of the Ontario Securities Act. It was, he said, a reprisal. So this was the first time this particular section of the Act was before the courts, and the 111-page decision provides a thorough background of the court's analysis. I'm going to give you the Coles notes. Next slide, please. So the key issue or the key clause that the court was deciding is it's the following: no person or company shall take a reprisal against an employee because the employee engaged in a protected activity. Reprisal, as you might expect, includes termination, demotions, discipline, threatening to impose a penalty, withholding a benefit. And to fall under the anti-reprisal protection, an employee must be engaged in a protected activity. And in this case, this means that where an employee would provide or intends to provide information to their employer, the OSC, could be law enforcement, about any act that they believe or reasonably believe contravenes Ontario securities law. This reasonably believes threshold is very low, and the employee just simply has to have a reasonable belief that's objectively reasonable on the information that's available at the time. So they don't have to be certain and they don't have to be right. The next part that the court spent a significant amount of time on is the word because. And the court concluded that the employee's participation in a protected activity only had to be a factor, no matter how small, in the employer's decision to take an adverse step in order to qualify as a reprisal. In other words, an employer could be terminating this individual because they had significant performance issues. But if it was even just a sliver of the reason was related to them reporting or saying they're going to report or raise questions, that would qualify as a protected activity, and that would result in this being qualified as a reprisal. So how did the court decide? You have it there. Yes, the court found that his termination was motivated, at least in part, by him raising concerns about compliance under the Security Act, and this amounted to reprisal. And then we get to the remedy. And under the Ontario Securities Act, it gives the court the power to award one or more of the following: reinstatement with the same seniority, or second, payment to the employee of 2 times the amount of remuneration they would have earned from the date of the contravention to the date of judgment. Now, Mr. McPherson had a base salary of $240,000 and $160,000 bonus, possible bonus each year. So about a total of about $400,000. In this case, the gap between contravention and when judgment was heard was over 5 years. So we end up with an award of $5,379,808. The court and the Act also does not require any deduction for mitigation. So Mr. McPherson or any person could go out and work elsewhere, but that will not be deducted from those amounts as it would typically in a common law, a notice type situation. So what do we do as takeaways? We could move ahead to the next slide, please. Okay, and actually this summarizes what I was just speaking about, the protected activities reasonably believed. We could move to the next slide as well. And we've got the monetary award and other damages. So the other damages, Mr. McPherson sought other damages, but the court found that they were denied because the statutory remedy fully compensated him. So they were not going to add on to the aggravated damages. Next slide. So the takeaways. First and foremost, anti-reprisal risk is real and it's very expensive. In Canada, boards must oversee compliance functions and respect prior regulatory orders, which was an issue in this case. The evidence that founders or related parties influence decisions, particularly after there's been reports, can be highly damaging. And so it's important to maintain independence, both process and in substance, and document it. When protected reports are made, they need to be treated and taken seriously, even when made internally. And even if it seems maybe petty or small, it's important to not discount these reports. It's important to, as well, if performance is an issue, as was raised in this particular case, it's necessary to ensure that it's documented, timely, and communicated. Having these allegations of performance come up after reported activity, particularly when they were not documented is not going to be helpful. And in parallel, it's important to avoid changing any reporting lines, excluding from meetings, withholding bonuses, or any other adverse steps after a complaint. Each of these can qualify as a reprisal. And then just generally, this anti-reprisal remedy is unusual, and it really can dwarf common law notice exposure. So from a litigation strategy perspective, if a case like this were to come up, it'll be important to carefully consider whether it is possible to have a principled early resolution, and then throughout the litigation, continuing to revisit. So across Canada, there are similar anti-reprisal concepts, and they exist in other regimes, for example, in employment standards and occupational health and safety. So the reprisal mechanism is one that to take quite seriously. All right, we're going to move to the next story or slide. Okay, yes, I think we largely covered that. We can move forward, please. Okay, so the next case I wanted to talk to you about today is Carroll versus Oracle Canada. And Stephen Carroll is an executive with Oracle Canada in a sales role. And he was there for about 3.5 years, 3.7 years. He was 61 years old. His base salary was about $180,000, but his average commissions were over $700,000. Let's move to the next slide, please. He was terminated as part of a restructuring. He was given 30 days working notice. After the termination, Oracle did not pay his commissions. Well, actually they did, but they didn't pay them right away. And it was until about 8 months later. And so there was this gap, but they did pay the commissions just after some time. Next slide, please. So how did the court arrive at 12 months? That's a hefty amount of notice. The age of 61 would necessarily, we would anticipate, be a factor in the 12 months notice period. But what the court really zeroed in on two things. The first was his income. He was earning over $700,000 in commissions, and the court concluded that it'd be very hard to replace this level of income, and so therefore was prepared to overlook the fact that normally salespeople are considered to have highly transferable skills, and generally the awards for salespeople tend to be lower. The second issue was the letter of reference, and actually, if we can pop forward to the next slide, I have the letter here. So this is the letter. To whom it may concern, Steve Carroll confirms his previous employment, says what his most recent role was, has an annual salary, yours truly. That's it. The court did not like this letter. If we can go backwards, please. The court said a few things. First, to suggest this letter was written to assist Mr. Carroll in his job search efforts is not credible. The court went on to say, this is the sort of letter is damning to an employee's job search. It is the sort of letter that an employer would write for a mediocre or problematic employee. And then it went further because often people will say, or employers will say, well, it's our policy not to write such a positive letter of reference. The response to that was, although they maintained that it was company policy not to write letters of reference, the letter did not indicate that this was company policy. So there's a couple lessons from this. One, if you're going to provide a letter of reference, to consider whether it's possible to beef up the letter, even if it's to include the roles and responsibilities that the person held at the time. And ideally, if it's possible to say one or two positive things about the person, that can be of assistance. If not, if it is strictly policy, not going to provide any positive letters of reference, then based on this, go forward would be to include in those letters, those form letters or confirmation of employment letters, to have a note that says it is our company policy not to provide letters of reference. Next slide, please. The other thing that was particularly unique about this case is the punitive damages. So in this case, what the court did is awarded punitive damages of $57,740.55, which was equal to the improperly withheld commissions for the ESA notice period. And the court found that the company had delayed payment for 8 months without a credible explanation. They didn't accept that the commissions were hard to calculate or it took time. And so they found that this was simply just not a good enough reason. And so even though they had paid after a period of time, they had to repay for the exact amount that they had withheld. And the court found that withholding this money was a form of acting in bad faith. And so it justified punitive damages proportional to the amount that had been withheld. I'm going to move to some of the takeaways from this case. First and foremost, prompt payment of minimum standards, notice, severance in Ontario, benefits, bonus, vacation, and of course commissions, as we see in this case. And again, this focus on the duty of good faith, taking evidence-based mitigation position. So again, in this case, the court actually also took umbrage with sort of bald statements that the person could have found other employment without really providing any evidence. And then the job references. It's important to have job references that are actually going to support the job search. And then on the equity word, so this is one actual bright line or bright part of this decision, is that the court found that the equity plan in this case was well drafted and enforceable, and that the employee was not entitled to further damages for the loss of RSUs. So it actually has the language in the decision, and it's an important reminder that all employers should reassess their equity and contract templates in light of recent case law and make sure that those equity plans and agreements are both aligned, unambiguous on vesting and damages during notice period. Two other things I would say about this case is really bottom line, the decision underscores a simple but critical lesson that it's really important to promptly pay all these legislated amounts. And that I expect going forward that courts will likely adopt this approach of saying, okay, you failed to provide vacation, it took you 3 months to pay vacation, so you not only have to pay the vacation, but there's going to be a damages award, or people will be looking for a damages award for this type of for these types of errors. So if there are errors, recommend dealing with them promptly. And on situations with commissions, if it's the case that it's not possible to know exactly how much is owed, making payments based on what you do know, and then making timely true-up payments as soon as the amounts crystallize with documented reasons for the delay will help guard against this type of damages claim. So with that, those are the two cases that I wanted to cover today, and I look forward to questions afterwards.
Okay, thanks so much. So good afternoon and good morning, depending on where you're based. I wanted to discuss intellectual property issues that I regularly see come up for employers. Unlike Colleen's presentation, which is about recent case laws, that we're responding to, this is more about practice points and things that are regularly coming up for our clients in this space. So if you can flip slides, please. So I'm going to just, before I get into the issues, I'm going to just give you a very high-level crash course in the various forms of intellectual property or IP, just so we're all talking about the same thing and are using the nomenclature correctly and are aware of sort of the peculiarities in each area. Then I'm going to talk about ways that you can protect your company's IP. And then the third thing is avoid some of the pitfalls that I've been seeing coming up pretty frequently in the last few years in terms of ways to avoid getting sued, particularly in the copyright space. So if you can flip the slide, please. Thank you. So there are three traditional forms of IP that are protected by statute in Canada. There's copyright, patent, and trademarks. Copyright protect literary, dramatic, musical, and artistic works. And there a subset within that in Canada is something called moral rights, which is our author's ability to be associated with the work and to not have the work mutilated. That lasts for 70 years. You don't need to register copyright in Canada, but it does provide you with some benefits. It's pretty fast and easy, so it's something you can consider. Patents are about protecting inventions. Shorter window, 20 years after filing, and you do need to file for protection in order to be able to benefit from that monopoly to exploit the patent. And then trademarks are logos, words. It's really about branding. You can have that in perpetuity. If you have it registered, it's just a renewal every 10 years. You don't need to register it to have brand protection, but there are a slew of procedural benefits and tactics that would urge you to file for protection if you're a brand focused company. So now one of the big, if you could flip the slide, please. One of the big issues that comes up in the employment context is who owns the IP. And there are different presumptions depending on what the nature of the IP is. So in the copyright context, if you have an employee in there and it's an employment relationship, and absent an agreement to the contrary, the employer is presumed to be the owner of the IP. And if, unlike in the States, if we have anybody from the US here, there's no work for hire situation. So if you are an independent contractor, you create something that's copyrighted. If there's no agreement stipulating who owns it, then the independent contractor would retain it. To retain the IP. And this is really problematic for employers if they don't have clear contractual language on this, because I'm sure many of you have heard about the emoji cases about contracts and oral contracts. That doesn't fly in the context of copyright law. In order for an assignment of copyright to be valid, it needs to be written and signed. And so there are real clear requirements. So best practice there is to include in your employment or independent contractor agreement statements around who owns what, and to the extent that that the employer doesn't own it, the employee assigns that copyright over to the employer so that you can't fight about it later on down the road. And we talked about assignments. So moral rights, that right to be associated with the work and that it not be mutilated or modified in any way, that can't be assigned. It's a technical point, but it's an important one, which is that it can't be assigned, but it can be waived in favor of the employer. So that's the sort of assignment of the copyright, waiver of the moral rights, and that's what you want to include. On the patent side, different statutory presumptions around employment. Courts have held that inventions created by employees are presumptively the intellectual property of the employee. There are some exceptions, like contracting out of that. So with that in mind, similar to the copyright provision where you want to assign that copyright over, you similarly want to have provision around assignment of the patents, that any patents that they create, any of those inventions. If an employee is hired for the purpose of inventing, that would be another exception. So you'd want to also stipulate in that particular individual's contract that that's the purpose of their employment, that they're actually hired for that purpose, and to cover all aspects of that potential issue down the road, you'd want to have that assigned to the extent it's not already owned by the employer. And then what you also want to see, especially if you're an IP heavy company, you want to make sure that the individual, the employee, will cooperate on protection, registration, and enforcement, and that's an explicit provision in your agreement, because what you don't want to happen down the line is you're sued for infringement, or you want to sue an entity for infringement, and the person who invented the product, the person who created the work, is nowhere to be found and says, well, I'm not going to cooperate. What good is it for you? So what good is it for me to help you? So in that case, if you have a contractual provision that'll help with registering for any patents or copyrights or trademarks and assisting in the enforcement, then you have that ability to bring them in to ensure that they will assist you in protecting or defending your rights. If you can flip the slide, please. So I don't include this in the typical 3 buckets of IP, but confidential information and trade secrets is very much within the umbrella. And an issue that has come up a few times, both in the case law and in practice, is the dreaded case of the employee on Friday says, I'm leaving and I'm going to a competitor, and you're scrambling about non-competes and what can you do. And in that case, a really important thing to do is do a forensic review of the employee's device. We've had cases at our office where we assisted the employer do that forensic review, and we identified before the employee started at a competitor that he had downloaded swaths of confidential information, client lists, pricing lists, customer data, and this was all part of the forensic review identified was that this all took place after he had an offer from the competitor. So with that information in hand, we were able to run to court, get an injunction from this person starting work at a competitor and potentially using that confidential information. Again, to the harm of our clients. So there are all sorts of common law protections about good faith, loyalty, and fidelity, and fiduciary duties, and that's all well and good, but a sound non-disclosure agreement and confidentiality provision that clearly delineates what's confidential and what is core to the business that the employer is looking to protect will be far easier to enforce against. And so we see lots of standard confidentiality provisions in these employment agreements. It's helpful to take a pause and think about the employee's role and what they will have access to, and specifically delineate, like, this is the Coca-Cola recipe. This is what they have, not the recipe itself, but they have access to this, prized possession. And if they left with this, we would be really in a lot of trouble. So we want to specifically delineate what is confidential for this particular employee, because the courts really spend quite a lot of time looking at those provisions to see what they took versus what causes harm versus what's in the provision. And so in addition to contractual protections, things that employers can do in the day-to-day is marking confidential documents as such. Remembering to take that step. If documents are emailed, include in the email that they're confidential. The availability to apply digital locks on files cannot be overstated. It's something that's accessible, and it really prevents sort of the risk of trying to put the toothpaste back in the tube, that the file's been sent over, but you can still, the document's been sent, but you can still have some protection in place to ensure that it won't be forwarded along. And when you're trying to enforce confidentiality obligations, one of the things that the court will also look at, not just the term, but what steps the company has taken to prevent the disclosure of the confidential information. So if you have these steps in place, like the digital locks, the policies, then that'll go favorably for you in trying to enforce against misappropriation of confidential information. A case that came out of the States recently, this is what I would call a bad facts making bad law situation, was that the court there found that passwords are not trade secrets. And I say it was bad facts making bad law, which is because an employee had brought a harassment complaint, and then in response, the employer said, well, you breached our trade secrets by sharing a password with another individual. And in that case, the employee was sick and asked one of her colleagues to step in and help with a file that she was handling and needed to share the credential in order to get there. But the ratio coming out of that case, which is that passwords may not necessarily be seen as confidential or trade secrets, underscores the importance of what you can do on the in the situation when an employee with confidential information is leaving and you're in that notice period, you can collect passwords, change them so they can't have access to it after. You can do those forensic reviews. You can ensure that you have all your ducks in a row. You can do the forensic review, and you can ensure that all of your rights are protected. And then the last issue that I want to cover, if you can, you already flipped the page. Thank you. Is instances of infringement done by employees and flowing up to the employer. So infringement is an absolute, these types of infringement issues are absolute liability. The fact that you didn't know it was copyrighted or patentable doesn't play into whether or not that there's been an infringement. So the two areas that we're seeing a lot of claims for copyright infringement are in the image scraping and in the open source software space. And what I mean is an employee will take an image, use it in a blog post, use it in a social media post without the requisite license. And it comes up more often than you'd like, where an employee doesn't appreciate the difference between something that's publicly available versus something that's in the public domain. So something that's in the public domain means the creator, the author of the work has been dead for over 70 years. So enjoy Leonardo da Vinci's works to your heart's content, but an artist that's living who's just posted their image on their page and now it shows up in Google Images, that's not in the public domain. So you want to ensure that that everyone in the organization understands that they are not permitted to use these images without the requisite license. And what we've also seen is individuals get the wrong license. They get it for personal purposes as opposed to commercial purposes. And it used to be the case that it was very hard to get caught in the before days, but now with all these AI scraping tools, they can easily find the infringement. There are entities whose entire purpose is to group catalogs, get the licenses, and then go after infringers. So we're seeing there's a huge uptick in demands for violations of the various licenses, and that in many cases actually does in fact constitute copyright infringement. There might be fair dealing, which is a defense to copyright infringement defense that applies, but if you're at the stage where you have to argue that, as opposed to spending, the $50 for the requisite license, you're in a lot. The legal spend will eclipse the cost of what the license would have been. So having that educational component, informing individuals not to do this, will pay dividends. Another area that we're seeing a lot of demands is in the open source software space, where a developer will, many tools for developers are open source, but they, again, like the images, there are licenses that apply. So just because something is open source doesn't mean it can be implemented in your company's software without taking certain steps. And if those steps aren't taken, then you may be infringing the copyright of the creator of the software. And software often falls into the category of literary works, which is protected IP. So that can be a very costly initiative. So the best way to mitigate that is to ensure that everyone in the development team knows that they are not permitted to use open source software unless their higher up signs off on it, and that they know what the license that they apply the right license, because it might be open source and that might be fine, but in many cases in a commercial context, it may not be. And what is required from the user of the open source license may not be actually done in the software, and so that way you would be offside. So the best practice education and policies to ensure that employees don't go offside relevant licenses. On the trademark and patent side, the issues that often come up are not doing the requisite searches before. So if you're creating a new tool, coming out with a new brand, you can in fact do searches in any of the countries that you want to operate in to see if that's going to be offside any patents or trademark rights of third parties. Just because, doing a internet search to see if that exists, helpful, good initial step, but there are databases that aren't necessarily searchable on Google that provide rights holders with registration and applications that might predate whatever usage you have in those jurisdictions. So it's just worth taking a pause before you launch to see what's going on in those jurisdictions. And that's it for my slides. I appreciate the 13-minute crash course in all things IP. If there are any questions after, I'm happy to address them.
Hello, everyone. I'm Elena Caceres, and I am going to talk about something completely different compared to what my colleague Meredith was talking about. But that's okay because it's a bit of a fun topic. So we often, when we're doing terminations for our clients, get into whether we should, make the termination effective day of or use working notice. And working notice has fallen into some disfavor among some clients because there is the issue of, well, this person is bad for morale, bad for the culture. We should just get rid of them right away. And in here, I'm talking more about a without cause context as opposed to a cause context, because of course, if it's cause, you should get rid of that person right away. But there are some cases where working notice can be really useful. And I want to talk about some of those examples. If we can go to the next slide, please. So generally speaking, before we get into the difference between working notice or pay in lieu at law, and this applies mostly across the country, but there's some nuances. So obviously when you're doing terminations, especially if you want to talk about the pros and cons of working notice, you should be checking in with your local practitioner. But the law generally is that you have to give someone reasonable notice, and that notice is working notice or pay in lieu of working notice. So working notice is actually part of the concept of reasonable notice. Now, sometimes we do salary continuance, sometimes we do what we call garden leave, where you're still working for us, you're still our employee, but you don't have to actually report to work, stay home. Those are technically not lawful under our employment standard statutes. The entitlement is you either have working notice or you are paid in lieu, and there's tight timelines under the employment standard statutes for pay in lieu. In BC, for example, it's 48 hours of termination if you've terminated the person without any working notice. So these things that we utilize as tools are still effective tools, salary continuance and garden leave, when we want the employee to sort of stay our employee but not actually have them working. But usually they have to be done either because the contract that you have in place with them is properly formulated and lawful, or they've otherwise agreed as part of a settlement to do it this way. So your notice has to be compliant with employment standards, labor standards, common law, and contractual entitlements. And hopefully you all have really strong contractual language in your contracts that allow you to minimize the amount of notice you need to give. And as I mentioned, working notice is less common than just you're terminated today and here's your severance package, goodbye. But when can working notice be effective? Next slide, please. Now, everybody will have different views on what is a good time to use working notice. I really like to use it when you're doing a group termination. And this could be, an actual statutory group termination of more than 50 people, or more than 40, depending on where you are, or more than 10. I think one of the provinces has 10 is a group termination, or a smaller group termination where you would have a department being reduced, and maybe it impacts 8 people or 20 people, but there's a reason to keep them working for a period of time while you implement the larger sort of big picture for the business, which is, maybe it's a shutdown, maybe it's an outsourcing, maybe it's just reducing headcount, but it impacts more than a couple of people, and therefore it'll be known within the company that these people are being let go after a period of time because of these business reasons and not because of something they did personally. And that is usually easier to sell working notice and to implement working notice because they're all kind of in it together. Sometimes you just want to keep people out of the market, and maybe you need time to make sure that they're not taking confidential information and that you've got your ducks in a row in terms of their exit. In that circumstance, you might do a combination of working notice and pay in lieu. Like maybe you give 8 weeks working notice to make sure that, you're keeping this person honest, and they have to kind of look you in the eye as you're negotiating their larger separation agreement, and then offer them something in exchange for a release as a lump sum. Cost saving, if you give a long notice period for a long-term employee, they still have a duty to mitigate and find something new. And if they find something new, you might not have to pay them the entire notice period. If they quit during the working notice period, in some cases, that could be a good thing. A lot of workers hate working notice. They would like a lump sum. So putting them on working notice can be nice leverage sometimes for a cost-effective settlement, because they'll say, give it to me as a lump sum. And, oh, if you want a lump sum, we'll give you less. And that can often be a good point of settlement. And sometimes you want to give working notice, I think, when you do have that long-term employee, and, maybe you want to do a retirement party, let that person say goodbyes. They're very well regarded. So you don't want to negatively impact the culture by, escorting them from the building because they've been terminated effective immediately. Um, so those are kind of the things that we might use working notice. And now I want to get into on the next slide, a few cases where we don't recommend usually working notice. So most individual or one-off terminations that are unrelated to larger restructuring won't really be conducive to working notice. Usually most of those people that you're getting rid of, if it's not relating to reducing your headcount generally because of budget constraints or operational reasons, is because they're, a poor performer, or their performance has been declining. And, it's very hard to do performance management to the point where you are able to terminate for cause. I tell clients it's virtually impossible, which I mean impossible, to terminate someone for just declining performance effectively for cause. So if you're thinking without cause and you put them on working notice, or they get wind of the fact that they're about to be terminated, your medical leave from that person is almost guaranteed. So I don't like it when there's a problem with the employee, because it could lead to other problems. Where your employee is bad for morale. If they're one of those people that, you're one step away from someone complaining about bullying and harassment, you should get rid of that person right away. You should not put them on working notice. And the flip side of that, if that person's a complainer, so you've got a history of this person always complaining about something, whether they brought a formal complaint under your policies or whether they're just complaining or critical of the workplace, you don't want them around. So you should get rid of them because they're likely to bring a claim against you anyways, and you shouldn't be having them around sort of poisoning other employees about how they think of you. So that's sort of my 2 cents. Others might have other views about when it doesn't work, but those are the general categories. So with that background, I want to talk a little bit about a recent case out of BC, which is just a really fun case in my perspective. And it deals with the working notice kind of ins and outs. And it deals with repudiation, which is one of my favorite topics, as, at my core, I am a bit of a nerdy lawyer. So in the Adrain and Agricom International case, we had a situation where an employee of 30 years service was given working notice of termination equal to 13 months. And the facts of this case are a bit wild, like they really are. The owner of the company sat down for coffee with this employee who had helped him found the company and started talking generally about how, I think I'm done. I think I want to wind down. I think I'll wind down the company. Oh, if you want to take over the company, I'll sell it to you for $1. Like this was in the facts of the case. The employee promptly, within a few days, sent a letter from a lawyer saying, if you're firing my client, you should know you have to pay her 24 months of notice because she's a long service employee and you need to commit to that in writing or else we'll sue you, basically. So the employer turned around and gave working notice of 13 months, which is low for a 30-year service employee. So you do have to evaluate what is appropriate. I think the owner with his counsel was probably taking into account that, even though you have a long length of service, if you have 13 months notice of termination, you can mitigate, you can find something new in just over a year. So that's not in the case. That's just me what I believe must have been the case as to why they picked 13 months notice as the reason, as the working notice period. So after that notice was given, the lawyer letters continued. And the lawyer letters from the employee kept demanding this 24 months notice. And then there was a letter where it said, if you don't agree to pay these entitlements, we're going to be suing you for wrongful dismissal. And then the employee did sue for wrongful dismissal. And then the employer did something I love. And you don't often get an opportunity as an employment lawyer to implement this strategy, but it's great. And that is, you're fired because you sued us, and that's a repudiation of the employment agreement. Oh, and if it's not a repudiation, it's cause. So what did the court have to say about this? Next slide, please. So the court said repudiation is not cause, and they went through some basics about I'll talk about what repudiation is. Repudiation is basically saying to your employer, I'm not going to perform this contract anymore. And the employer accepting it as kind of a revocation of your contract. So, but the court said, no, it's not cause for termination. We have non-binding mixed authority in British Columbia about whether or not it's cause, and it's fact specific. And I think on the facts of this case, it's not cause because, the letters were clear on the intention and there was no misconduct by the employee. So here on these facts, it's not cause. Maybe it's facts in cause in other cases, but it's not cause in this case. But then they went through some very clear appellate authority regarding how if you sue your employer, that is repudiation. So repudiation is, again, rejecting that you have to perform your contract. So that meant that employee had repudiated the contract, but what does repudiation mean? Next slide, please. So these are the basics. Definition of repudiation, a contract. Repudiation is a declaration that the repudiating party, in this case the employee, is unwilling or unable to fulfill its obligations. So the principle from the BC cases, and I don't actually know of any contradictory principle in other provinces, although the facts will dictate whether or not a repudiation has occurred. An employee who commences a wrongful dismissal action against an employer after receiving notice of termination without cause during the working notice period commits an unjustified repudiation of the contract. Now, there might be an exception here if you're giving somebody working notice, but you're telling them they don't have to report to work, or you're taking away their direct reports, or you're restructuring their employment during the working notice period. Maybe you're giving them a constructive dismissal basis, at which point they could continue to work without having repudiated the agreement, having asserted constructive dismissal. So that's a bit of an exception. Now, unlike termination for cause, if you're terminated for cause, you get nothing. But if you repudiate the agreement, that doesn't mean you don't have a remedy. So in the appellate cases that the court relied on here, it was noted that you can still get damages for repudiation of contract if your rights accrued before the repudiation accrued. So at the end of this case, next slide, please, we have a circumstance where the court found she repudiated, but she had already accrued prior to repudiating because she had been terminated and given working notice. She had already accrued this right and entitlement to 24-month notice period. So the court agreed with her lawyer that the proper notice period for 30 years of service was 13 months. But now we had to do some math. And lawyers are not that great at math, but I can tell you all the correct math is on the slide here. So she should have worked 13 months notice. She worked 1.5 of it, 1.5 months before repudiating. The employer also paid her for a few weeks after the termination period, probably to cover the ESA period. It works out about to 8 weeks total with the amount she had worked. And then she failed to work, though, the balance of her notice period, which is 11.5 months. So the court deducted 11.5 months from the 13 months that she should have worked because she didn't work it from the 24 months, which is, a pretty, if you're following the math, she ends up getting about what her working notice period would have been. There was also a deduction of about 1 month for what we call a contingency discount because the lawyer brought the lawsuit under our fast track rules, which requires the court to schedule a trial and have a trial within 3 or 4 months of pleadings being closed and the plaintiff seeking a trial date. So this trial happened 4 months after she repudiated. And the judge said, well, we should do a bit of a discount because she probably will get a new job in under 2 years. Now that discount was just 1 month, and the judge did not adjust for failure to mitigate because the employee had shown some efforts in mitigation. But when you do all the math, like she barely made the money that she would have made had she just continued working for the 13 months. So even though it's a little bit convoluted, working notice can be effective and can help the employer with a defense and with some tools if the employee sues anyways. So that's kind of just an interesting case which pulls together repudiation and working notice. Because, this case tells us that if you do working notice correctly, the employee doesn't really have a lot of recourse. And if they try to sue you for additional amounts, the fact that they repudiate the contract can be used as a tool in court as a defense to minimize your exposure. Now, of course, the case is still terrible in some ways because, everybody paid legal fees, everybody spent time, but it's an interesting roadmap to how you can make working notice work for you. Now, just some key facts, key items for working notice as I wrap up. You do have to create a plan. Like there has to be a plan that works in each province. If you want to do working notice, how do you roll it out? Do you do an FAQ because it's a large group? Do you do a town hall for everybody because a bunch of their coworkers are impacted? If it's a smaller group, what's the timing? How do you explain it to them? You need the sort of implementation plan to have a lot of detail to it and making sure, of course, in consultation with your human resource and legal teams that it's all correctly, all the T's are crossed and the I's are dotted in terms of how much notice you're giving and what kind of split you're doing between working notice and pay in lieu. If you need people to work, like I've done working notice for large groups where about 10% you really need them not to quit on you. You need them to finish implementation of whatever project before you outsource the work or whatever the case may be. In those cases, we often consider retention bonuses to make people stay the full working notice. Consider what you can negotiate to sort of reduce your overall aggregate exposure for long-term employees. We often have success with part working notice, part lump sums. If you are implementing longer working notice periods, I think you should still encourage people to, we'll give you reasonable time off for job searches and help them mitigate because that might reduce your overall exposure to them as well. That's, of course, for the people that you don't mind if they quit early, as opposed to the people you want to give retention bonuses to. And there's a lot of moving parts. There's a lot of statutory moving parts if you are dealing with a group termination, usually more than 50 people at one time. But working notice can be very helpful. So if you're considering it, talk to someone about what it looks like for your particular circumstances, and you can get some advice and you can make it work for you.
Awesome. All right. Thank you, Colleen, Meredith, and Eleni for your insights. We do have a few quick questions, and I think time to get to maybe one or two. First one is for Eleni. It's with respect to an injury during a working notice period. Specifically, does the employer have an obligation to accommodate during that time? And is there any risk of proceeding with the termination at the end of the working notice period, as previously planned?
I mean, there's risks. So working notice, something to evaluate is what's the likelihood of a medical leave, or, you have to be comfortable that it'll be business as usual for a period of time. We have had people get injured or need accommodation during working notice. If they're still working, working notice continues, like nothing has changed. It's often more difficult if the person gets injured or goes on leave before you've actually notified them. But if you notified them, you have a framework for moving forward. So if the person goes on leave, it kind of stops the clock on the working notice, but you have a situation where they want to come back to work and you can elect to say, okay, we were terminating you and it's been 6 months of the 8 months notice period we were giving you that you've been away. So we're just going to pay you out, unfortunately, 8 months because, if they're not working, you haven't paid them or fulfilled the working notice. So you'll have to convert the package in many cases to a pay in lieu package. And often there's some discussions and some negotiations because, if someone ends up kind of critically injured and is on long-term disability, you have to sort of work with that person to say, look, we owe you this termination package. When do you want it? Do you want it now, or do you want to delay it while you're sorting out what's going on with the insurer and having that kind of discussion? But once the amount of notice is crystallized, you owe that person that money, whether they work it or not. So I don't think that you could say the timeline on working notice continues even if they're absent or even if they're on reduced hours. Unlike other accommodation situations where we would reduce pay based on their hours, in a working notice situation, you might not reduce pay because you owe them the money. So that's a situation that's difficult and you have to get it right. And that for sure, you should be seeking advice of an advisor if that comes up. But that is a risk that often precludes working notice in some cases.
Great. Thanks, Lenny. I think that is it for time. Other than that, we appreciate your time and engagement today, and we look forward to connecting with you soon. Thank you so much, everybody.